Now, the Supreme Court is hearing the CBI's plea challenging the Delhi High Court order that suspended the life sentence of former Uttar Pradesh MLA Kuldeep Singh Sengar in the Unnao rape case. Now, the matter is before a three-judge vacation bench led by Chief Justice of India Surya Kant, along with Justices J.K. Maheshwari and Augustine George Massey. The CBI has argued that suspending the sentence of a convict in such a serious offence sends a wrong message and must be reconsidered. The court is now examining whether the High Court's decision to grant relief to Sengar should stand or be set aside. In a plea, the CBI has in fact strongly challenged the Delhi High Court's decision to grant bail to Kuldeep Singh Sengar in the Unnao rape case, arguing that the court erred in ruling that Sengar, an MLA at the time of offence, was not a public servant subject to prosecution under POCSO. Now, the probe agency referred to its verdict in the L.K. Advani case, in which it held that anyone who holds public office like MPs or MLAs would be deemed a public servant. The survivor has been following with the case, and protests had been held earlier at the High Court today in the morning, and there were protests that were held at the Supreme Court as well. Meanwhile, the Solicitor General has in fact argued on behalf of the CBI. It has said that it was an act of public servant and that this is a horrific case of rape that was done to a child. He said the victim was around 15 years, 10 months when the crime was committed. My colleague Savya, in fact, joins on with us from the Supreme Court. Savya, there is a lot of to and fro that's going on between the justices as well as the SG as well. The big argument being that there have been lapses with regard to how the HC has in fact viewed the provisions when it comes to the IPC sections 376 and also at the same time the section 5 and 4 of the POCSO Act. More importantly, whether Sengar was in fact looked into as a public servant or not.
That's right, Varghese. See, the entire argument going on right now is regarding what is the definition of a public servant. In fact, in the petition which the CBI had filed to the Supreme Court, they had mentioned about L.K. Advani that in one of the hearing, the Supreme Court itself had accepted that the MLA or a MP can be considered a public servant. Now, for viewers, to simplify things, the Solicitor General have said that the POSCO Act offences can be broadly classified in two categories. Now, what are the two categories? Penetrative sexual assault is per se an offence. 4 provides for punishment. In 2019 amendment for punishment, it was not less than 10 years max and life in certain circumstances. There's aggravated form. The categories are that if a person is in a dominant position, then it is considered an aggregated form under which the CBI carried out the investigation, and as per the sections of POSCO Act 5 and 6, he was given life imprisonment. Now, the Solicitor General Tushar Mehta also pointed out that the public servant not defined in POSCO Act by reference, whatever defined in IPC will be the definition. Every word used in any statute is not mechanically getting definition. Public servant would mean a person who is in a dominant position over child. Now, the Solicitor General also pointed out, giving a reference in A.R. Antoli, the SC has said that MLA is not public servant, but was that in facts of the case. When cognizance was being taken, he raised issue about 1947 PC Act, which did not have definition of public servant. Court construed in context of the act whether sanctions was needed, and CGI had said that, see the intent, the court did not want to grant him protection of being public servant. So clearly a lot of to and fro at this particular time going on, where very importantly the Solicitor Solicitor General Tushar Mehta had pointed out that at the time when the incident happened, the victim was a minor. The victim was around 15 years, 10 months old. She was not of 16 years old, and under these circumstances, the CBI has very efficiently carried out the investigation. They have submitted all their findings and evidence, and under which the conviction has taken place, and the Solicitor General clearly disagreeing with the decision that was given by the Delhi High Court regarding the suspension of the life sentence of convict Kuldeep Singh Sengar. Back to you.
Also, there is, interestingly enough, as that to and fro in fact goes with regard to whether the person was a public servant or not. Now they say that because it's a POCSO Act that is there, there is no need to find out what the position the person in fact holds. The POCSO Act becomes quite relevant in the case. Is that how the SG is in fact arguing?
Well, that's right. See, the POSCO Act itself becomes quite relevant, and the Solicitor General Tushar Mehta, that is the reason why pointed out that there are various stages of the POSCO Act, and the findings and the evidences which has been provided by the CBI in the case, and under which on that basis the trial court in fact have convicted Kuldeep Singh Sengar, finding him guilty and finding him that the rape was conducted in an aggravated manner, and that is the reason why life sentence was given to convict Kuldeep Singh Sengar. And that very point Solicitor General Tushar Mehta have been highlighting that the stricter section of the POSCO Act has been implemented in the case because A, the victim was a minor at that particular time, and also Solicitor General pointed out that how the decision that has been given by the Delhi High Court can have an adverse effect on the mental health of the victim, because there is a continuous threat to their life, because it is out in open what has happened with her father, what has happened with a lot of family members of the victim, how they were killed. Her father was killed in the police custody, and several of her relatives lost their life in road accidents. So under these circumstances, there is a continuous threat to the life of the victim, and Solicitor General Tushar Mehta also pointing out and giving a definition of the public servant, because that particular procedural lapses was exploited by the lawyers of Kuldeep Singh Sengar when the matter was heard at the Delhi High Court, and the Delhi High Court stating that the MLA or the MP does not come under the category of public servant as it has not been mentioned, and that is the reason why Kuldeep Singh Sengar's sentencing should not come under the stricter section of the POSCO Act, and rather it should come on the lesser strict section of the POSCO Act, that was section 4, and that amounts to 10 years of imprisonment. And since Kuldeep Singh Sengar had almost served around 7 to 8 years in prison, and that under these circumstances the bail was granted to him, and that very point has been highlighted by the Solicitor General Tushar Mehta today, and a lot of to and fro is going on between the CGI and the other justice and the Solicitor General Tushar Mehta regarding what is the definition of the public servant in this case.
Well, also we have in fact come to know that there has been an effort on the part of the CGI to in fact understand the case as such. He said that, interestingly enough, he said that let's assume for the sake of argument that he is not a public servant under Section 5, then he falls under Section 3. The amendment did not create a new offence but merely enhance the punishment. So the argument has also been going on that there should be 20-year punishment that should be attracted on this aspect as well. In fact, we have some big news that's coming in. Supreme Court stays HC's order on Sengar's bail. Supreme Court stays HC's order on Sengar's bail. This is the big story that we are in fact breaking at the moment. Supreme Court stays HC's order on Sengar's bail plea. Supreme Court has been hearing the arguments. The SG had in fact argued with regard to the situation on the ground, where he in fact said that there has been an err on the part of the HC on this particular aspect of whether the person is a public servant or not. For more on this, I'm joined by our input editor, Brijesh Pandey. Brijesh, finally they have the Supreme Court going ahead and in fact placing a stay on this order, probably looking at all the legal issues that would have surfaced in this, also the misses that the High Court had. How do we in fact see this particular aspect of the stay? Because there could be a stay on the order, but the case is still going to go on.
On Varghese, because you know, the order of the Supreme Court will again be challenged, and I think the proceedings will go on. But I think, you know, the big breaking which is coming out is that Supreme Court has stayed the Delhi High Court's order on Kuldeep Singh Sengar's bail, and you know, the Supreme Court clearly has gone with the arguments which has been put forth by the CBI side, which was led by Solicitor General Tushar Mehta. And you know, Tushar Mehta in its argument made it very clear that there were two dominant narratives. One, the CBI, the Delhi High Court did not took into the cognizance about the fact that into Section 376 of the IPC and also Section 5 of the POCSO Act. They also said that the CBI had proved beyond shadow of doubt that Kuldeep Singh Sengar was at that point of time a public servant. Apart from that, they also said that one of the things which, you know, which the court has to take into consideration was that the victim at the time of rape was 15 years and 10 months old. Therefore, she was clearly a minor. And once you take into consideration that the accused had a dominant status in the society apart from being the MLA, then it makes it an aggravated sexual assault case. And the court had said that the reason why POCSO was invoked was that the victim was a minor. The SG also went on to say that Section 376, which is a rape section under IPC, has two parts, and you know, then rape by someone who enjoys a dominant position, then the minimum prison is 20 years or can extend to the biological life. You know, to which the Chief Justice of India, Suryakant, asked that are you trying to say that if the victim is minor, then the High Court order is not justified because the accused cannot be considered a public servant? So what they're saying is that the act itself, the fact that a minor was raped, is a clear-cut given scenario that the concerned accused should be tried under Section 5 of POCSO and also under Section 376 of IPC, and also the fact that the accused enjoyed a dominant status also points to the aggravated sexual assault. Therefore, the minimum sentencing which we are looking at is 20 years for sure. I think they requested the Honorable Supreme Court that the stay should be granted, and the court, you know, inclined with the argument put forth by the Solicitor General of India, agreed, and the Supreme Court has ordered a stay on the Delhi High Court order. It's a big breaking as far as you know, in the Unnao rape case is concerned. If you remember, when the judgment of Delhi High Court had come out, you know, it sent shockwaves across the country, and there were a lot of protest which was there. The victim came forward and said that the way judgment was delivered is a clear case of subversion of justice. And if you look, I think, you know, after this, the role of the investigating officer, which was clearly held in the fact that he was not able to perform his duty clearly by both the lower court and the High Court. Varghese?
Also, interestingly enough, a lot of interesting arguments have come with regard to the question of whether retrospectively something can be applied or not. The question about ensuring that the very act itself was perpetrated on a minor. So the question of whether the person is a public servant or not, the fact that it was a crime that was committed on the minor itself brings in the stringent provisions of the POCSO Act. So all these clearances have been in fact put in place. Thereby, now how do you see it in fact moving in the arena? Because we had seen a series of protests. The stay order could be the first kind of victory for those who have been supporting the survivor.
Well, I think, you know, this makes the future very difficult as far as Kuldeep Singh Sengar is concerned, because, you know, the fact is that the Solicitor General also pointed out that this particular case, when it was being argued in the Delhi High Court, you know, they said that the lawyer had argued that in the A.R. Antule case, which involved corruption, and this was the parallel which was given in the case of Kuldeep Singh Sengar. But the fact of the matter is that the Kuldeep Singh Sengar case also falls under the POCSO Act. So whether he is a public servant or not becomes irrelevant. If he is tried under POCSO Act, then the minimum which you are looking at is 20 years, and it can also be extended up to your biological life. Clearly meaning that you have to spend the rest of your life behind bars. What made it aggravated case was the fact that the accused enjoyed a dominant status, and also the fact that he is facing another case and is behind bars for the murder of victim's father. So I think, you know, the Apex Court was seized with the matter, and hearing on all these detailed arguments which has been put forth by the CBI, by the Solicitor General, clearly put a stay on this.
Right. We all...